If you die in Texas while owning real estate and you don't have a will and the property's not in trust, there needs to be a legal process to transfer that real property into the names of your heirs. If you left a spouse, just because you and your spouse jointly own that property does not mean that it automatically becomes 100% owned by your spouse. There needs to be a legal process that has gone through to transfer the property from 50% yours and 50% theirs to 100% theirs. This can be avoided by a transfer on death deed or by putting the property in trust. But if you haven't done that, your spouse is going to have to go through the probate process to get the house transferred into their name. It's generally pretty difficult to sell a house during the probate process. Depending on whether you have a will or not, and depending on whether there are minor children involved, you may need court authority to sell that house. In addition, to be able to sell the house, you need to have at least gone far enough through the probate process to have had the executor or administrator named and approved by the court. That can take several months by itself to get there. And in the meantime, the bills still have to be paid for the house, the mortgage has to be paid, the insurance needs to be kept up. And sometimes that can put a real strain on families to do that while the probate process is ongoing. The probate process is part of the process of transferring title to real property. If you owned real property and you pass away, then to transfer that property into the names of your heirs, whether that's your surviving spouse or your children or someone else you've named, the property has to go through probate. Your will has to be approved, or your heirs have to be named in a probate process so that someone has authority to transfer it into the right person or person's names. To do that, they'll do a new deed and create that deed to transfer it from your estate to the new owners. The decision of whether to sell a house that you've inherited is a big one. Some of that will depend on whether you are going to be the sole heir or whether you have co-heirs that may or may not want to sell the house. Sometimes we see situations where maybe there are 3 siblings that have inherited a piece of property and one of them wants to continue to own the home. So you're going to have to figure out these things. How are you going to own it together? Are you going to sell it? If you're going to own it together, who's going to pay the taxes and provide upkeep for the property? There's a lot of considerations that go into that. Typically, you're not going to be allowed to list a home for sale while it's in the probate process. First of all, either an executor or the personal administrator has to be authorized by the court to act on behalf of the estate. So until that happens, nobody has authority to sign a contract to sell the house. There's a lot of questions and concerns that come up when you're dealing with real property in the probate process. We have lots of experience in this area and would be glad to help you. Give us a call at DeFord Law Firm.